But tonight, let's get some other legal perspectives to the Twitter matter. And I'm being joined on the program tonight by rights activist and senior advocate of Nigeria, Mr. Falana. He joins us virtually from Ikeja area of Lagos. It's good to see you, Mr. Falana, and thank you so much for creating time to talk to us right here on Channels Television. Let's begin the conversation. And first and foremost is the plans by the federal government to meet with Twitter. It looks like there is a negotiation. The federal government says that Twitter has written to it and therefore set up a committee that has some ministers in that committee to meet with Twitter. How does that come to you, Mr. Falana?
Well, I think it's a good development. But in many instances, we put the cart before the horse. I thought this should have been done if the government had protested to Twitter when it was dissatisfied with certain development. This kind of meeting would have been called much earlier, and the embarrassment and the inconvenience to which Nigerians have been subjected will have been totally avoided. So I think it's a good development that both sides are going to meet. I think it's a welcome development.
The other side to this matter, I'll come to what they should be telling Twitter based on some of the things the federal government has said. The other side to it, as a senior lawyer, there are those who have debated about the jurisdiction of the ECOWAS court in this matter, and perhaps the opinion of the senior lawyer who was also on the program yesterday, Mr. Festus Keyamo, as to whether or not the ECOWAS court will be the one, the compass, the moral compass in the affairs of Nigeria, or how the federal government should run the affairs of a citizen. Let me get your take on the jurisdiction of ECOWAS, the ruling of yesterday, and in the eye of the law, what do you make of this ruling, and what are the implications?
Well, in the 60s and 70s, it was convenient for dictators in Africa to plead sovereignty, and that nobody should interfere in our internal affairs. But in this stage and time, once countries have submitted part of their sovereignty to international bodies, in this case, the ECOWAS, Nigeria has ratified the protocols establishing the court, as well as the supplementary protocol. It is therefore too late in the day to rush back home and say, we are independent, we are a sovereign nation. You have already admitted that your activities can be examined by supranational court, like the ECOWAS court. And what happened in this case, as soon as the Socio-Economic Rights and Accountability Project, SARA, filed the action before the ECOWAS court, alleging that the right to freedom of expression of Nigerians has been violated by the suspension of Twitter. The government joined issues. The government raised objections, serious objections, and anchored this objection in particular, and this was very embarrassing, on certain provisions of the penal code relating to sedition. Of course, we made it clear to the court that all the provisions of the criminal code or penal code relating to sedition were quashed, were declared, illegal and unconstitutional in 1983 in the case of Otonwanko and the state. And therefore, one would have expected lawyers in and outside government to familiarize themselves with the current position of the law. That in Nigeria today, nobody can work provisions of the law on sedition from the grave and use them to harass or intimidate Nigerians. And for the ECOWAS, and this is not the first time the ECOWAS court has intervened with respect to access to internet. In the case of Amnesty International and others, and Togo, the ECOWAS court in 2017 declared illegal, null and void, the decision of the Eyadema government, Togolese government, to ban access to internet in that country. Also, in the case of the Gambia, the ECOWAS court has had cause to annul Yahya Jammeh's anti-media laws in that country and directed the government of Barrow, to ensure that the laws of that country were amended to reflect, democracy. In the case of Nigeria, Section 24 of the Cyber Crimes Act of 2015 has been annulled by the state court, and what the ECOWAS court has said this time around, yes, Mr. Falana, we cannot go into the suspension. We cannot suspend the suspension of Twitter for now. But with respect to the fear and the threat of the Attorney General and Minister of Justice, Mr. Abubakar Malami, SAN, that violators of the suspension might be prosecuted. The court came in to say, violators, there should be no prosecution pending the determination of the suit, and that is where we are. And happily, today, after the Federal Executive Council meeting, I think the spokesperson for the president, Mr. Femi Adesina, did announce that the order has, gone to has been submitted to the Attorney General of the Federation for legal advice. And I will not expect the Attorney General of the Federation, who is the national authority for the enforcement of the judgments of the ECOWAS court, to give any advice that will render the judgment or the ruling arbitrary, So people may not like what has happened, but the choice is to go back to that court, perhaps ask for a review. But nobody can sit in his office and say, oh, we're a sovereign nation, therefore the ECOWAS court cannot interfere. After all, we went to International Court of Justice with respect to the Bakassi Peninsula. And when the ruling was given, we had no choice but to comply. And this is not the first time Nigeria has complied with decisions of the ECOWAS court.
One thing that would come to mind is the argument that when a government, like a father that is the head of a home, discovers something that is inimical to the security of his home or his country and takes action in that respect, and that's where the conversation around national interest, issues of national security overriding individual rights or rights of an average citizen. And so when people say, well, not everything that goes on Twitter or social media platforms are healthy, or there's some things that are going on those platforms that are dangerous to the security of the country. So in that sense, when the federal government makes a pronouncement such as a suspension of Twitter, is it law in the eye of our constitution or in the eye of the body of our laws guiding operations of our country?
Well, it is very important for the government, and indeed all Nigerians, to appreciate that we are operating under the rule of, and that implies that if you are going to violate, if you are going to breach or infringe on the fundamental rights of Nigerians, embodied in Chapter 4 of the Constitution, as well as the African Charter on Human and People's Rights, you must pursue, you must take any action under a law, under the procedure permitted by law. In other words, if you are going to say, I cannot enjoy my freedom of movement, and you want to seize my passport, you must go to court and get an order. If you are going to search my house, you must go to court and get a warrant, search warrant. If you are going to arrest, unless the person is caught committing the offense, you must have a warrant of arrest. If you are going to violate the right of Nigerians to access information, you must approach your court and get a court order.
Apologies there because of the frozen frame and the glitch in the network. And of course, Mr. Femi Falana is trying to react to some of those issues.
Now, somebody has threatened the security of Nigeria. Therefore, we are going to seize his house or seize his telephone or deny him access to information. You must go to court and get a court order. That is what is required.
So invariably, Mr. Falana, the federal government should have gone to court. Is that what you're saying?
Oh, yes. Oh, yes. Oh, yes. Because we're not dealing with Twitter alone. We are saying Nigerians have no right to access information via Twitter because Article 9 of the African Charter on Human and People's Rights guarantees access to information. So if you want to stop and want to infringe on that right, you need a court order so that all those who are affected will say you have to take their interests into cognizance. That I'm not just dealing with this Twitter, but I'm dealing with millions of subscribers, about 40 million of them.
So, I mean, one of the things Mr. Lai Mohammeds said yesterday when he was facing lawmakers, he said the reason for the suspension of Twitter was because it allowed activities on its platform which, according to him, promoted the destabilization of Nigeria, especially separatist groups. He made specific reference to the use of social media during the End SARS protest. How would you react to that statement?
Again, this government cannot be taken seriously when it makes such a point, because the president and officials of the government had been communicating with Nigerians via Twitter. Even after the ban, there are officials of the government that were alleged to have defied the ban by using their Twitter handle. So I'm therefore going to submit with profound respect to the minister that no official of the government has the power to decide in itself that an organization has destabilized Nigeria. And therefore, I am the accuser, I am the judge, I am the witness, I'm the prosecutor, and I hereby find the organization guilty. If the government has such evidence, what is expected is to file an action in court. But in this case, the government has been...
Yet again, there's another obstruction there because of the network glitch, okay, Mr. Falana is back. Yeah.
The first reason I used for the suspension was that the president's tweet was deleted. That was the first reason. It was much later. I think the government was embarrassed that, we'll be shifting the goalpost. We were now told, oh, because Twitter had not deleted the tweets of the IPOB leader, Mr. Nnamdi Kanu, oh, Twitter is partial. Okay, that was over. The government now said Twitter had been found to have violated certain laws in Nigeria, has breached national security. The latest one now is that Twitter should be held vicariously liable for the End SARS protests. Meanwhile, we know that those who protested last year were fighting against police brutality. The government, Mr. President, said, we have heard you loud and clear, and we are attending to your demands. The government claimed through the same Minister of Information and Culture that the government has met the demands of the End SARS protesters. At what time now did the government decide to hold Twitter vicariously liable for the activities of the End SARS movement or for the killings that took place, killings that are being investigated? The same minister had said nobody was killed in Lekki last year. So far, Evidence has been laid that people were killed at the Lekki toll gate, among other places. So I think we must be very consistent. The government must learn to allow people to take it very seriously. And you cannot do that if you are consistent and you follow the rule of law. The government will not be embarrassed.
Let me, since the federal government says they're going to sit at the table with Twitter, what do you suppose that the federal government should be telling Twitter?
Well, I do not work for the government. I want to believe that both sides, will have to engage in frank discussions. If the government has its own fear or certain reservation, that will provide an opportunity to engage, and let the Twitter, owner appreciate the position of the government. And I think there should be some meeting point, but we just have to appreciate that the rights of Nigerians are involved. There are young people in their thousands, if not millions, who earn their living, by taking advantage of Twitter, and the government itself. We're now being told there are other fora. If Nigerians accept that story, what stops the government from banning Facebook tomorrow? Or Instagram, or any of them? And that is why we must learn from this case that we need to, at any time, the government must put the interests of Nigeria over and above any other consideration.
All right, Mr. Falana,
when you talk of national security, Seun, it's about the security of Nigerians, the security of the country, and not the security of government officials. There is a difference between government security and national security. But most of the time, governments in this part of the world hardly draws the dichotomy between the security of government officials and the security of the nation.
We're out of time, but if you may, Mr. Falana, maybe in 30 seconds, if you can help us, the consideration for the amendment of the Nigerian Press Council Act and the National Broadcasting Commission Act has raised eyebrow, and there are allegations of high-handedness, and for those who think that the government is not being truthful, and the presidency has reacted that the presidency is not involved. What's your view on the amendment process?
No, I think since the presidency has cleared the air this afternoon, that it's not involved in the whole exercise, I think the sponsors will have to go back to the drawing table and perhaps do the needful by withdrawing the proposed amendment and then engage. Again, we must learn to respect Nigerians. You must engage all stakeholders, particularly the members of the NUJ, the Guild of Editors, MPAN, and others, so that we can have a common position to protect the interests of Nigerians. But once these are simply rushed to the National Assembly without consultation, you have this kind of embarrassment. And I'm going to advise the sponsor that the timing is very bad. They should have waited and allow the crisis with Twitter to be resolved before rushing bills to the National Assembly.
All right.
And again, my last advice is that the sponsor should attempt to familiarize themselves with the state of the law on freedom of expression in Nigeria, in West Africa and Africa, so that we do not embarrass ourselves any further.
I must sincerely thank you so much tonight, Mr. Falana, for your insight and some of the legal perspectives you put into the matters discussed tonight. Thank you so much indeed for your time.
Thank you very much. My pleasure.